Hello, everybody. This is Salil Tripathi at the Palais des Nations in Geneva at the UN Forum for Business and Human Rights. And I'm talking to Brynn O'Brien, who is a lawyer and an activist who has been working for some time on the issue of the way in which migrants and refugees are being kept in Australia in detention centers, including private centers. Can you tell me what's going on and tell me why it is such an important issue?
Yes, and thank you for having me. I work with an organisation called No Business in Abuse, which aims to end corporate complicity in the abuses of immigration detention. Australia's policy of mandatory and indefinite detention of asylum seekers who have arrived by boat has been in place in various iterations since 1992. Australia has a number of detention centres on the mainland. We have one on Christmas Island, and then we have two in other sovereign nations. One is in Nauru and one is in Papua New Guinea on the island of Manus Island. Private companies are contracted to run these centres. In the offshore centres, the company is an Australian Stock Exchange listed company called Broad Spectrum Limited, and they are responsible for providing essential services that keep these centres running. The types of abuses that we see in immigration detention are violations of fundamental tenets of international law, arbitrary, indefinite, prolonged detention, and in fact, Australia's system has been found to violate that prohibition on arbitrary detention by the UN Human Rights Committee 8 times, as well as very bad conditions which may amount in some circumstances to cruel, inhuman and degrading treatment. So currently we have around 1,500 people that Australia, with the assistance of Nauru and Papua New Guinea, as well as companies, that are being detained in these offshore centres.
And why is it a big problem? Is it a genuine abuse? Is it that they're completely being denied due process? Is it, to what extent does it violate international law, or is it within the remit of international law?
So my organisation released a report in October this year, which demonstrated that the system of offshore detention violates 47 different principles of international law, and that's everything from the prohibition on arbitrary detention to cruel, inhuman, degrading treatment to violations of the right to health and child rights and so on.
And when we look at it from the current climate, war on terror, and the fear that the person who comes from outside is likely to do some harm to the society, to what extent are governments justified in taking some of these steps, particularly when the flow of migrants and refugees has been so unending in many countries?
So we have to make a distinction here between measures taken to control migration and then measures taken to actively deter people through cruelty. The system of offshore detention is one that relies on deliberate cruelty, and international law says there is nothing that justifies that. No national security justifies this sort of abuse.
What would you want the companies to do? Not bid for the projects, let the state run them, or if they do run, operate by certain principles? And if so, what are those?
We had an initial period of engagement with the company where we put some proposals to them. We gave them information about the abuses that were occurring and how they violate international law. We then put some proposals to them for how to overcome those abuses and the abusive conditions of detention. The company initially agreed that the standards that we put to them were appropriate, and that if they were named as the preferred tenderer in contract negotiations for a further 5-year contract, then they would seek to exercise leverage over the government to meet these minimum standards. Since, however, they have been named the preferred tenderer, their position has slightly changed. Their current public position is that it's not their place to influence government policy, and what they're doing is domestically legal. And as we know, under international law, that doesn't matter. If you're doing international law abuse, it doesn't matter that it is legal in the country in which you're doing it.
So what remedy is available? Do the guiding principles provide any framework for a remedy, or does it mean someone has to go to a national contact point at the OECD, or should it be a lawsuit?
So remedy will be a focus of our campaign in the future. So far, because this situation is ongoing and urgent, our current focus is to stop the abuses. But then, of course, there will be a period of trying to assist victims to access an effective remedy. Unfortunately, the situation for Australia for litigating in Australian courts is rather unclear at this point, although there is some ongoing litigation in relation to personal injury. But Australia has, for example, no Human Rights Act, so it's not possible to litigate under a human rights statute of any sort in Australia. There are ongoing complaints with the Australian OECD National Contact Point in relation to previous detention centre operators, and my organisation is considering making some more complaints in the future.
So are there any parallels to be drawn or lessons to be learned from the Guantanamo experience? Because one case I do know is a Norwegian company which had faced lobbying by Norwegian and other international NGOs, which led them to stop the contract at that time. There was another company which also was providing catering services at that particular facility, and which also had to respond to those concerns. So is that the way forward in the absence of the law, to go after the companies directly by appealing to their codes, or by appealing to international standards that apply to companies, even though they may not be legally binding?
Yes, and that is certainly the approach that we have taken and will continue to take. The companies, however, so the companies maintain a position that none of this is legally binding, but what we have found in our engagement with the rest of the private sector over the last 12 months is that while these accords may not be legally binding, they are very, very important to many of the stakeholders of these companies. So the financiers of these companies are worried about being associated with this type of human rights abuse and the reputational, financial and legal consequences of that association. But you are absolutely correct to draw the analogy between this situation and Guantanamo Bay and the provision of catering services, and in fact that's one that we've relied on in our conversations.
Are we in a situation where these kinds of campaigns can extend? Here in Europe there are these private, if not private, even if they're state run, but there are detention facilities for migrants and refugees given the current refugee crisis in Europe. Is there a need for an international binding instrument for that? Or there is always a fatigue for international instrument, or do we have enough in the current international law and standards from which something can be drawn?
In terms of whether the No Business in Abuse campaign has any current plans to expand internationally, the answer is no. We're very, very busy with the Australian regime. In terms of whether there is any parallels that can be drawn between what's happening in Australia and what's happening in Europe, Australia really does stand alone in the world in its policy of mandatory indefinite detention, where people are kept in detention centres and not allowed to leave for years. Europe currently does not have a similar system, and we certainly hope that the supervisory jurisdiction of the European Court on Human Rights would stand in the way of any moves in that direction. That said, there really is a need for us to, as a business and human rights community, look at how immigration detention is being privatised and how some of the most vulnerable people in our society are being abused.
Thank you very much indeed, and all the best with your work.
Thank you for having me.